Anyway, so thankfully, for you and for me, I'm not talking about GDPR, but Stefan Geering, who is the Global Privacy Officer at Blackboard, is going to. So welcome, Stefan.
Thank you very much. Is this microphone working? Can everyone hear me at the back? Yeah. Excellent. Well, first of all, thanks for you guys to having me here, and thank you all for coming to the session. I hope you took the opportunity to take all the sweets that you had and all the coffee with lots of sugar to kind of prepare yourself for the riveting topic of GDPR. So I want to talk a little bit about myself, not too much, before we go into the topic itself. I'm the Global Privacy Officer at Blackboard, so I'm responsible for privacy and helping with kind of security from a legal perspective globally. I'm not going to go through all the detail, but interestingly, I actually started way back when I was still in Switzerland at the Data Protection Authority as the Deputy Data Protection Commissioner and worked with schools and universities as well. So it's kind of coming full circle back to the education sector. And one thing I wanted to share, and maybe I'm oversharing here a little bit, is that I really don't like to go to the dentist. Who in here likes to go to the dentist? Well, that's what I actually, oh, there is someone, okay. So I know a lot of you don't like to go to the dentist, but I really hate going to the dentist. When I was a child, it was so bad that my parents tried to bribe me with Lego and other toys. Nothing helped. I just wouldn't sit still on the chair. So it got so bad, they had me bring to hospital, general anesthetic, and fix my teeth. So why I'm talking about my paranoia and fear of dentists? Well, I think there's a little bit of an analogy here. So if you actually really good, brush your teeth every day, twice, for 2 to 3 minutes, then you can avoid a lot of pain later on. And data protection is actually not too different. A little bit maybe, but if you actually invest your time to day by day, do a little bit on data protection, have your process in place, you save yourself a lot of pain later on. And obviously, if you really have clean teeth, you also have a shinier smile. So maybe I'm going a bit far with this analogy, but I just want to kind of give that as an introduction because I think it's really important that data protection is not something you just did during GDPR, now it's all good and you can let it go. It's actually something you need to think about it day by day. So what I'm going to talk about is, first of all, I want to talk about what kind of impact has GDPR had on organizations generally, and then also on the data protection regulators. But that's obviously important because these are the bodies that bring in enforcement, that can fine organizations. So it's important to understand what they're doing. I can't avoid talking about Brexit, but I promise it's only going to be about data protection regarding Brexit. I'm not going to venture into the very, very interesting topic of Brexit otherwise. And then, of course, I'll try my best not to spend too much time, so there's not any time left for questions. So hopefully we have some time for questions at the end, and otherwise I'm, of course, around later on if you can ask me any questions if you want to. So impact organizations. James mentioned it. I think does everyone hate GDPR now? I think what people will remember is the thousands of emails that came in the email, please consent, here's a new privacy policy, and people are like, oh, go away, I can't stand you. And this is actually quite a nice example, actually. It took a bit, ironically, the whole approach. But not everyone hates GDPR. A lot of people love it. We privacy professionals, of course, love it because it gave us a good reason to be more important and do a lot of important work. And if you believe it or not, there have so many people who actually love GDPR that there are now whole gift sections for GDPR. GDPR gifts section on online web pages where you can get socks like this if you're really, really desperate. Not even I have those, I have to say. But seriously, so data protection, what has happened? So I think the important thing here is that for a lot of organizations, this has been a bit of a wake-up call because if you look at the principles of the GDPR, they're not really that different from what we had before, but a lot of companies kind of, data protection, maximum fine of 500,000. So obviously now with GDPR, potential fines of up to 4% of global turnover, that has focused a lot of senior management attention, boards of organizations, And that's been quite helpful to drive kind of the impact and making sure that GDPR is being implemented. At the same time, I think it's also, just from what I heard from various clients that I've been talking with, it has been difficult for some of universities actually to get even that senior management attention. If you don't have that, if you try to do everything kind of bottom up, if kind of the IT department, of the legal department has to do this all themselves to kind of try to get colleagues to help, if it's not coming from top down, very, very hard to do it. And of course, a lot of data protection experts have been hired. People have been looking for data protection officers. Law firms have, of course, made a fortune. Probably one thing I regret is that I haven't kind of founded my own consultancy company. I could have been very rich and wouldn't be here anymore if I've done that. So a bit of a stupid move from my part. And of course, GDPR programs have been rolled out. But I mean, that sounds so easy, rolling out a GDPR program, but it's actually very, very difficult. I mean, first of all, you need to have, again, the right governance around it. You need to kind of make sure that you have people on the top who support you, that give you maybe a bit of project management support, that make sure that you can go to an external law firm to get help. And then there's also the substantive aspect of kind of, once you have all that support and actually doing understanding where is all the data, all our vendors that we have, find them, because maybe you don't have a very well centralized procurement process and it's really, really difficult to find out which program everyone uses. So there's lots of challenges, but obviously with the GDPR, that has given the pressure to kind of do this a bit more rigidly and rolling that out. And of course then, I mean, I think I'm just mentioning one of those legacy issues that people have been trying to address as part of GDPR is kind of record retention. I mean, that's such a difficult challenge to attack in every company, and I think that's something even with GDPR hasn't been resolved in many companies so far. So what has been the impact then since the 25th of May? I think a lot of companies and organizations have and should have focused on making sure that new processes work, making sure that actually new projects go through a process where they complete a data protection impact assessment if needed. And a lot of companies have also kind of dealt with individual right requests. And maybe some of you know, I mean, from your organization, have you seen a big spike? Same level of requests for access to correction, deletion data? More? More? Yeah. I mean, we've seen a little bit more, but not tremendous. And I think it varies a bit by industry sector. And I was a bit surprised because I thought, okay, students, they would be a bit more interested in how their data is being used, but maybe not as much yet. But I think almost more importantly, kind of in these last 6 months, kind of look at how the GDPR has impacted data protection authorities. And the GDPR has, of course, created a lot of work for them. So they had an increase in complaints since the 25th of May. So the CNIL, the French Data Protection Authority, for example, had a 50% increase just after GDPR in June. We have seen complaints from organizations like None of Your Business, from Max Schrems, which is the guy that brought down Safe Harbor. We have seen Privacy International raising complaints against Data Broker. There's a lot of complaints that go through the whole investigation process at data protection authorities. Then, of course, there's the new breach notification requirement. So data protection authorities are flooded with notifications of breach incidents. So the ICO has recently kind of given guidance that they think actually 2/3 of what they get is actually not reportable from their perspective. So I think a lot of companies have taken the approach that we are overly cautious, we just notify any kind of data breach. And of course, for Data Protection Authority, that's difficult to wade through all of that and see what's actually the real dangerous one and what is not as dangerous maybe. And then, of course, then the data breaches that are becoming public and data protection authorities like the ICO need to react to, something like the British Airways breach, the Facebook breach that we've seen, the whole Cambridge Analytica investigation that absorbs a lot of time. So data protection authorities have really been quite reactive and they've been trying to kind of deal with all these new requirements and the obligations, and all the obligations they also have from this new consistency process, which makes sure that the EU data protection authorities talk to each other, are consistent in how they apply the GDPR. But interestingly, and I think good, is that some data protection authorities actually try to still be proactive and not just react to what's coming their way. So we've seen the CNIL, for example, the French Data Protection Authority, they have published a data protection impact assessment kit that's kind of free to download. I think there's even an English version, which is really helpful. The UK Information Commissioner's Office is now trialing a so-called sandbox approach, where they try to kind of help new emerging technologies to kind of, in a kind of protected environment, kind of find their way that's data privacy compliant, but also not kind of inhibiting the kind of the growth of new technologies. So that's helpful. And I think the most interesting aspect that I've seen is that what the Dutch Data Protection Authority has done. So they have just literally sent letters to 30 randomly selected big businesses in the Netherlands and asked them how they're complying with Article 30, which is the requirement to have a register of data processing. I think that's brilliant, I mean, from a Data Protection Authority perspective, because you basically sending a signal, just by keeping a low profile, not having any data breaches, you can't just get away with not complying. We're just going to randomly target organizations. That really makes organizations sit up. So that's quite an interesting example. So we haven't really seen any major enforcement action under the GDPR. So we have seen Facebook fine, but that was under the old data protection regime. So what's happening? And I think it's a bit too early, of course, to have big enforcement cases already. But we have seen two interesting cases, and I'll just talk a little bit about those, because I think they have some interesting aspects to it. So one is the ICO's enforcement notice against Aggregate IQ Data Services. So Aggregate IQ Data Services is a Canadian company which was involved in the whole Cambridge Analytica micro-targeting of voters. And the ICO came to the conclusion that they actually received data from UK parties, but what they did is they processed that data without having a lawful basis. They used it for different purposes that they should have, and therefore they issued an enforcement notice against that. And the initial enforcement notice was literally banning them for processing any UK or EU residents' data, which is pretty dramatic. That's much more drastic than a fine, I think, for those kind of data companies. But then the company challenged that, and the ICO had to amend the enforcement notice. And what it says now is just that they need to delete the data of UK residents, so not talking about EU residents anymore, that was processed under this, during this particular time frame. So they had to kind of significantly scale down the enforcement notice. I think that kind of shows two things. I mean, first of all, the regulators are very much still kind of focusing on the whole kind of ad tech profiling industry. That's one big focus. But also the second aspect is that companies will now start pushing back, because with the GDPR, the enforcements are more stringent and more trusting and more impactful on business. So businesses will not just kind of take a fine and let it go. I think business will start challenging those decisions. It's interesting also with the Facebook fine. I'm not sure if you've seen, but Facebook has now decided to appeal the fine of 500,000 for their kind of involvement in the Cambridge Analytica saga. And again, I think that's kind of a trend that we see, that companies will challenge those decisions more. The second case I want to talk about is one from France, considering a company called Vectory. Anyone heard of Vectory before? No, I have to admit, I haven't either. So Vectory is an advertising network company that helps their clients, so various businesses, to sell advertising space. And they also developed a software development kit that can be included in apps. So that app can then use geolocation to target advertising to specific clients, even if you walk around in a shop. Now the thing is, they actually implemented a consent mechanism, so the end user of that mobile can consent. But the CNIL said, well, it's not good enough, because what they're consenting to, they're not really sure what they're consenting to, so the consent is not really specific enough. Because first of all, they can't choose between I don't want to give my geolocation and the other data, so they should have split that up. Secondly, there's not really full transparency in terms of third parties. And then during the investigation, Vectory actually started to implement the Iab Consent Framework, which is a quite well-established framework in the meantime that a lot of companies use. But the CNIL came to the conclusion, well, that's not good enough either. So that's actually quite a traumatic decision, even though there was no fine, it was just a warning that they need to change their practices. But that's quite a dramatic notice in terms of kind of this could change how the internet advertising industry needs to operate. So it's going to be interesting to see how that's going to pan out. And again, I think the interesting aspect is here, this is a rather small decision in France, but this could actually have impact across Europe, how the regulators enforce advertising-related practices. And I think the second thing that it shows is also that because now these decisions in various countries may impact other countries under GDPR much more, I think it's important that data protection professionals and your data protection legal colleagues at universities also need to kind of not just focus on what the ICO is doing, but also what other companies are doing. And then before I forget, of course, we had an announcement from Giovanni Buttarelli, who is the European Data Protection Supervisor, who is responsible for the EU institutions' data protection compliance. And he mentioned that there's actually quite a lot of enforcement decisions in the pipeline, and that includes, first of all, enforcement against public authorities. And secondly, the interesting thing to note again, that it would include at least temporary bans on processing. And again, I think it's interesting that because a lot of people have kind of, whenever we talk about GDPR, it's the fines, the 4% global turnover fine. But if you actually found by the regulator to have breached data protection law and you banned from processing certain categories of data or of certain residents in a certain countries, that could be really devastating. So the last thing I want to talk about regulator is talk about the EDDP. And who in this room has heard about the Article 29 Working Party? Ah, a few. Very good. So the Article 29 Working Party used to be the group of data protection authorities in the EU, and that was the group that coordinated their opinions and made sure that there's consistency in the application of the previous European Data Protection Directive. Now with the GDPR, initially the idea was that to make that into a much more of a system of a one-stop shop. So you would have your regulator in your country that's fully responsible for you. You don't have to deal with any other data protection authorities in the EU. As part of the legislative process of the GDPR, that got watered down quite a bit. So it's not as stringent as it could be, but the European Data Protection Board is now the successor organization that helps coordinate this whole decisions between cross-border compliance efforts and enforcement. So if there's a breach that impacts residents in the EU, in Germany and France, the EDP would make sure that the enforcement is consistent and that also penalties would be consistent. So there's a lot of coordination powers and obligations on the EDP. And secondly, they're also responsible for issuing guidelines on the implementation and interpretation of the GDPR. So for example, what has been just announced is that they will be issuing their guidelines on the extraterritorial application of the GDPR. So as some of you may know, the GDPR also applies to organizations outside the EU if they offer goods and services into the EU to EU residents, for example. And it's not very clear how targeted that offering of goods and services need to be. So it's going to be a very important guideline, particularly kind of for our clients and every organization in the US that provides products and services to EU residents. And importantly also, the EDDP gives opinions on adequacy of country. So who knows the concept of adequacy in data protection? Okay, I tried to explain it very, very briefly. So data protection law has this idea that because the EU has such a high level of data protection, we need to make sure that when data is transferred outside of the EU, that data is protected to the same standard. And that's called adequacy. So you can achieve that either by declaring that a country is adequate and whitelisted, and we have a few countries like my home country Switzerland, Norway, Israel, Argentina, and a kind of small number of countries that we already have before. And then there's also the adequacy of certain mechanisms, like you may have heard the Privacy Shield, we have the famous standard contractual clauses that allow data transfers. And the EDP gives those opinions if such a country can be considered adequate and also their mechanisms. So it's going to be important from a Brexit perspective in terms of the UK. And what we've seen from the European Data Protection Protection Board is really, I think, promising, because previously the Article 29 Working Party has been a bit of an opaque organization that made the decisions behind closed doors. They issued opinions, and then people would just say, oh, that doesn't make sense. We hadn't had any chance to give any input into that. And as part of GDPR, they started to at least kind of take feedback on board. They revised some of their opinions that they drafted initially. And they have now also kind of started to be really transparent about their agenda. So they're kind of publishing their agendas for the various meetings and have a better website presence. So I think that's all very, very positive signs. Because I think it's important for regulators to be transparent so that companies can really anticipate and kind of make sure they know kind of the direction the regulators take. And it's also interesting, I think, that the European Data Protection Board has taken a really good initial stance in terms of making sure there's consistency. So under the GDPR, each country has the ability to define additional requirements for when a data protection impact assessment is necessary. And of course, the danger here is that in every country it's slightly different, and the countries have this ability. But the EDP has actually issued 22 opinions on the various countries' requirements for DPIA, and that's been showing kind of a really good handle on making sure that these can be as consistent as possible, which helps a lot making sure that if you're operating in various countries in the EU, that you can apply kind of similar standards. So taking all of this together, I mean, what should organizations be doing? And I've got a few thoughts here, and obviously there's much more to think about, but I think the important thing here is that, again, while the data protection authorities are really focused on kind of the online advertising, data broker space, I don't think anyone should feel complacent and think, we are under the radar, we don't need to comply, it's all going to be fine because they're so busy with the Facebooks and the Googles of this world. I think we're going to see, as part of this GDPR enforcement, a heavy focus on finding and bringing enforcement notices against a lot of companies. And I think through that, we're actually going to see that the various data protection authorities set new standards in areas where it may be a gray area, there may be different implementations, how something has to be implemented. And I think through that, I could well imagine that there's almost kind of a second wave of GDPR work. So the regulators will set some standards that people may be surprised because they took an approach and a decision that because of the lack of resources and because you need to prioritize, that they may have not gone to the gold standard, and suddenly one of the data protection says, no, I want that gold standard. So I think there's going to be a lot of work following the kind of the first wave of enforcement, making sure that certain things are being picked up, and again, not just on kind of the new requirements regarding data protection impact assessment, the privacy by design approach that every company should have in place, but also the pre-existing requirements around security, which is a very broad principle, but some of the data protection authorities may take a view on what that actually means in one specific case, in terms of encryption, in terms of minimization, etc. In terms of records retention, and of course making sure that your vendor management is good, and it's not just kind of contracts in place, but you're actually conducting some due diligence on your vendors. And of course, I mean, what's really, really important is kind of the ongoing awareness and training programs, because I mean, that underpins everything, and making sure that your staff understand what the requirements are and where they can find your experts and where all the policies and standards are, where they can find more information. So you may have noticed so far I've been really, really good at not talking about Blackboard. But of course I need to grasp the opportunity a little bit to talk about what we are doing at the moment. And I think it's not just because I want to advertise Blackboard, I think that's kind of an insight into what kind of every vendor should be doing or should thinking about doing. I think, and that's obviously only a few highlights, I mean we're doing more, but that's just a few highlights to kind of show here. So I think one thing that we focused a lot on is kind of our internal governance. So we have a network of what we call data privacy champions. These are our colleagues in the various departments, kind of the internal departments like HR, finance, tax, etc. And then we also have our contacts in our various product teams. So for our learning management system, we have a contact. We have a contact in our Ally, which is our accessibility tool. So we're making sure we have a contact there and that we use them. So when we have information requests, we can go to them and say, how actually does this particular system work, and what kind of data is used where and stored where. So we can get a lot of information through them. But we also train them. So we have regular kind of meetings with them where we kind of explain to them specific aspects of the GDPR, also other laws around the world that are important for them. So kind of building that network that your data protection experts in your company, or sorry, in your institution are not alone, I think it's very, very important, because if it's just one person trying to do everything, that's not going to work. The second thing we're doing is we're looking at the moment at kind of our contracts and data processing agreement. They're of course fully GDPR compliant already, but what we are looking at the moment is that I think we've seen a really interesting trend that our clients in South Africa, our clients in the United States, our clients in Australia say, I want GDPR as well. And we thought, we're basically taking the GDPR as a standard across our company, so why shouldn't we give them GDPR-like rights? So we're working at the moment at kind of putting much more of kind of the obligations on us and the responsibilities from our EU-specific data processing addendum actually in our contracts applies to all our clients. And then really, really exciting, we have, and I think that's core for every company that develops products, is kind of the privacy by design approach. Privacy by design means that you're really thinking about privacy, not just at the end when you have a finished product and kind of, oh, how do we tag on privacy? But you actually, as the product develops, you start thinking about, okay, how can we minimize data collection? How can we make sure what we do is transparent to the end user? And we're actually developing now a new platform, and that's public knowledge, which is called Blackboard Data, which is kind of our underlying data platform. And we're working very, very closely with that team to help them kind of steer through all the privacy obstacles that may face and make sure that this platform really is really solid from a data privacy perspective and meets the expectations of our clients and their users. And to make sure that that really works, we have kind of a combined privacy by design data protection impact assessment approach. And of course, if a high risk, then we're going to go through the kind of a bit more cumbersome and detailed data protection impact assessment way. But to make sure that this really works, we have now started using a company like Viawheel, and there's lots of other companies available. But we're using Viawheel, and that helps us automate our workflows around it. So you can actually see how many data protection impact assessments and how many checklists are outstanding. You can automatically follow up with this. And I think these tools are crucial. I think in 5-10 years, it's going to be, every company going to have them, because if you're on your own, you're trying to kind of do this with Word and email and follow up, and you forget half of them. You have a spreadsheet, and you don't update it, and where was that? So I think tools like that are going to be indispensable in a few years' time. And I think also the regulators will expect you to have such tools. Just like in information security, you have certain tools that regulators will expect you to have. And related to that Viawheel, this company and their tool actually also helps us with kind of two really interesting projects that we're working on at the moment. And one is around the automated data mapping. And I have to admit, I was always a bit skeptical about these companies selling their data mapping tools, because you can have your Article 30 register of processing without mapping every data element in the company. But I think if you use, particularly if you kind of use cloud services, an automated tool is going to be really, really helpful to stay on top of this and make sure that you really capture it. And for us as a company that services institutions like yourself, it's incredibly helpful to not just have an internal visibility, but then also kind of to provide that view to our clients. So we're kind of working at the moment to kind of try to have that almost real-time view of where is the data. Is it encrypted or not? Who has access to it? And then the idea is that at some point, and obviously as a lawyer say, we're not making any commitment to any timelines, but at some point, we can actually provide our clients a portal where they go in and say, my data is stored in Amazon Frankfurt, and the client support team from Colombia has access to it, and the development ops team over there in India has access to that. So I think that's going to be incredibly helpful for our clients, also for us, because at the moment how we do this is lots of emails going back and forth. Are we still doing it like this? Are these guys still having access from there? So it's really not a manageable process, and that again helps us automate it. And similar regarding the use of our APIs, our application programming interfaces. I mean, we use those for integration with other products. And obviously, there's always the danger that data flows out of there and you don't have full visibility. I think we're very different to kind of the issues that Facebook had, because in the end, our clients can activate or deactivate those, so they have control over that. But you have kind of granular visibility again for us and for clients. I think it's going to be really, really crucial going forward. So we have started working with the API teams and with Viabil to kind of find ways, how can we make this more visible to ourselves and to our customers. So that's some really interesting projects that we're working on at the moment I'm very excited about. And then, but again, a bit more mundane, but I think it's really important to kind of keep monitoring, and we do that a lot, I spend a lot of time kind of monitoring what's going on. What is the ICO doing? What is the CNIL doing? What is the EDP, European Data Protection Board releasing? Because this is really kind of a fast evolving landscape, and staying on top is really important. So I mean, I'm sure you have kind of your selected law firms that send you some newsletters. So make sure you read them. I know it's really hard to find the time, but it's crucially important. Oops, wrong direction. Oh, Brexit. Okay, I need to have a sip of water first. So Brexit from a data protection perspective is really interesting. So there is, there's a few articles in the draft withdrawal agreement, and of course we don't know if that draft withdrawal agreement is going to survive as it is, if it's going to change, but assuming it will survive as it is at the moment, there is one article in there, Article 71, which has some, even as a lawyer I have to say, incredibly vague and complicated language in there, and I've read it 5 times. I've read, I think, 4 different law firm analysis and a few detailed blogs, and I'm still not entirely sure what it exactly means. So I think that statement there is a really, really good summary. In reality, nobody has any idea how this is all going to play out. And I'll leave it at that. No, I'm joking. I'm going to explain a little bit what it should probably mean. But again, with the caveat that we don't know what's going to happen, and we're not sure if our interpretation that we have at the moment is absolutely right. But I think the good news is that, that both the EU and the UK, of course, want to make sure that there is consistency, that data can flow between the EU and the UK in both directions. So during the transition period, the UK will continue to apply EU data protection law. And that EU data protection law terminology, of course, means it's not just GDPR, it means any kind of data protection related law like the e-privacy directive or e-privacy regulation if it ever comes through next year. At the same time, during the transition period, so the EU and the UK will try to get to an adequacy decision, which means that the UK would be considered to have the same standard or kind of equivalent standard of data protection like the EU. But what they said is there will be no emergency adequacy decisions if there's a no-deal scenario. So if we crash out of the EU on the end of March without a deal, then there is no adequacy. But if you have a transition period, then the idea is to work on that. Now, that's really nice, but I mean, considering how long it's been taken for other countries, and there's kind of South Korea and Japan at the moment in the pipeline to get that adequacy status, if the transition period is until the end of 2020, I think that's super optimistic to think that you have an adequate decision by the end of that transition period. If the transition period is longer, as there has been some kind of indication, then maybe it's realistic. The other thing that's quite important is that the ICO is very unlikely to stay a member of this European Data Protection Board, and as mentioned, that is a really important body now. In terms of the GDPR, so the UK cannot influence the decisions around there. Quite likely, maybe they possibly remain an observer of that body. So what's happening after transition in case of a deal with a transition period? So possibly there's an adequacy decision in place. I think that's unlikely. Possibly there's no adequacy, and in that case, I mean, I put the whole sentence there, that what the article says, I'm not entirely sure what that means, but basically, it should mean that EU data protection law is still applying to EU residents. The UK, of course, has its own Data Protection Act 2018, which applies to UK anyway. And very interestingly, there's almost something like, I call it a backstop, I'm not sure if that's the right term, but it's almost like a data protection backstop as well. So in Article 71(3), it actually mentions that if the UK should lose its adequacy status, then it still commits itself to have an essentially equivalent data protection level to the EU. And that could, depending on how long the transition period and the negotiations deal, that means that the UK basically needs to follow the judgments of the European Court of Justice regarding data protection, and obviously all the opinions of the EDP. So that's interesting. But what does it mean for institutions like you and the organizations? I think the assumption really should be there will be no automated adequacy. So if you have kind of data transfers into the EU or from the EU to you, then I think the assumption is, particularly from the EU to the UK, that it's prudent to have alternative data transfer mechanisms in place, like the model clauses or the standard contractual clauses, they're called. The UK, I think, is a bit more hopeful because I think the UK will recognize the EU as adequate so that you don't need a particular transfer towards if you send out any data to, for example, your vendors that are based somewhere in the EU. But again, that's no guarantee because at the moment, of course, everything is still very political. So yeah, unfortunately, not a very pretty picture. I think the good news is that the parties have committed themselves to really work hard on this, but if they really get there where there's kind of a seamless transition and the regimes play without any additional measures, I think it's rather unlikely. Okay, I have no idea how well I'm doing on time or not, but we have now time for questions. I'm just going to skipping forward one. I've included an appendix in my slide deck, and I hope you can find the slide deck somewhere on the website. Excellent. So you can find those links there. And obviously, thank you very much for your attention, and please feel free to heckle me with any challenging questions.
Anybody got any questions? I knew that would be the highlight of the conference. Right, have we got a microphone down?
Hi, I don't know what I did in a previous life, but before my job now, I was the GDPR program manager, and now I'm delivering a core system in the Open University. So my question relates to test data management, which you've not mentioned, but it's the thing that fills me with the biggest amount of horror, how we are able to test in that environment, but without the use of live data. So have you got any advice around that for us?
Yeah, so I mean, again, I think, and that's a really difficult one, so good question. I think GDPR hasn't really changed anything. I mean, because the requirements to minimize the data that you use, the personal information that you use, the personal data that you use, has been the same before. So GDPR just changes your risk in terms of enforcement around all of that. But what I think is really crucial that you as an institution have a policy around it. It should be based on the principle of minimization. If you can do testing with de-identified data, where you hash certain data elements or strip it out or do whatever you can, that's fantastic. If you need to use personal data, and I think you need to just be able to make a good case, quite possibly want to conduct a data protection impact assessment around that, where you demonstrate that I tried all of this, but in the end we still need live data, so that's what we do, but we minimize it by being transparent, by documenting it, by making sure that we have really limited access, etc. And I mean, ideally you have kind of a two-stage policy where, say, generally the approach is we don't use live personal data, but we can approve it in exceptional circumstances where it really warranted, and you can kind of demonstrate that goes through that approval process. I think that there's no perfect solution to this otherwise.
Any other questions? Maybe time for one more. Yes, over here.
I think a lot of universities... Hi, for a lot of universities, event capture is one of the main areas of concern and complexity around GDPR. Have you got any sort of standard guidance or process with, between the use of Blackboard for publishing event capture and event capture within universities, really. I mean, having just worked on a DPIA, making changes to our event capture processes, it's not an easy area.
Yeah, sorry, you need to explain to me a bit more. So what capture area are you talking about?
Lecture capture.
Lecture captures, okay.
Yeah,
yeah.
sorry. Lecture capture, automatic scheduling of lecture capture, desktop capture, student assessments captured that way, any event sort of retention of that type of thing, use of that type of thing outside of the immediate educational viewing, etc., etc.
Yeah, and I think it's I mean, again, I think it's quite similar to what everyone should have done before, but it's important, I mean, that you go through kind of the typical kind of questions, what's kind of the lawful basis for doing so. And I talked a little bit about consent. I think consent is very often not a really good idea to use because the standard for consent is extremely high and it's really only valid if someone can say yes or no. So particularly in the context of student, of your staff, if you ask them to consent to storing some of their data, that's quite often not that helpful because they don't really have a choice. So very often you would rely on other data processing legal basis. And secondly, I think it's kind of the typical aspects of how long do you really need that data. So you have kind of retention periods, what kind of purpose are you using for, and giving all that kind of as transparent information to the individuals so they are informed that they can make use of their rights. I think that's really one of the key things, and that you giving that information to individuals, but you also have that information documented for yourself as part of a data protection impact assessment, or if you need to assess if you use a legitimate interest, that you have that all nicely documented, because at some point maybe the regulator will challenge you, an individual will challenge you and go to the regulator, and you're going to be very happy to kind of take that sheet of paper or kind of electronic copy out of your drawer and say, we actually thought about this and this is what we thought about it. Because even if you made maybe a wrong decision, if you can demonstrate that you put a lot of thought of it, and that's kind of how you came to the decision, then I think your risk of actually getting a significant enforcement action is going to be very, very low, even if you made the wrong call, but if you can demonstrate that you actually put a lot of effort and time into making that call.
Thank you very much.
Thank you.